Thank you, Madam President.
Senator Latz.
I also had a question. Maybe Senator Ingebrigtsen can clarify for me. It looks to me like the existing bill would completely remove from the district court, and this is again in Section 7, would completely remove from the district court review of the EIS when there's an appeal or a judicial review sought after the responsible governmental unit has made its decision. And I wonder if Senator Ingebrigtsen could verify for me that that is the effect of the bill in its current language.
Senator Ingebrigtsen.
Madam Chair and Senator Latz, as I stated before, this would allow the environmental review appeals to follow the same process of the environmental permitting. I think that's what you're talking about.
Senator
Madam President, I'll take that as a confirmation that the bill makes a pretty dramatic change then in the current process for judicial review of environmental impact statements. And the current process is that an appeal would first go to the district court, which would be venued in the county or where the project is proposed, and the local governmental unit, the responsible governmental unit, the RGU, has made its decision. Judicial review, while not a separate evidentiary or evidence-gathering proceeding, is easily accessible to the local population that wishes to closely follow the proceedings relating to the permit that has been sought in the project that's being proposed. Where under the current bill then, that legal proceeding would be moved to St. Paul. So no matter what part of the state you're from, if you wish to personally observe the judicial proceedings, you would have to travel to St. Paul in order to observe that. And as a practical matter, for many people in their own communities, that frankly would not be practical. They would not be able to take the time away to make a 3 or 4 or 5 hour drive in order to certainly a lot fewer people would be able to do that than could currently go to the local courthouse to observe the proceedings. The other concern I have with that provision is that when there are local permits that are involved separate from the environmental impact statement, such as building permits or zoning variances or something like that, those would still be venued for judicial review purposes in the local district court. So you would end up having, if there were questions or legal issues relating to those local permits, you would still end up with district court proceedings on the case, and then if there were further challenge, appellate court proceedings after that. So you would not end up saving any additional time from that standpoint. You're still going to end up in district court. So it would just seem to me that it would make more sense, if there's going to be any local permitting involved, and the district court is the appropriate venue for that, that as long as the district court is handling matters relating to the case, they could also handle the environmental impact statement judicial review and include that analysis, as is the current law. But then you're really not having that much, if any, duplication, because the district court is already going through an extended legal analysis of the proceedings. And in the event that there were any kind of a frivolous attempt to challenge a local permit, just for when there wasn't any merit involved in that, just to try to get it into district court, well, that would be thrown out, and the lawyers would be, and the parties would be subject to either Minnesota Statute Section 542 sanctions or Rule 11 sanctions for bringing non-meritorious or frivolous lawsuits. It seems to me that we would end up actually eliminating some duplication anyway if we had the proceedings in local district court for the EIS, as well as any local permit reviews that did have a meritorious challenge to be in district court. And for that purpose, Madam President, I'd like to offer the A7 amendment.
Secretary will report the amendment.
Senator Latz moves to amend House File Number 1 as amended pursuant to Rule 45 adopted by the Senate February 17, 2011 as follows. Page 10, delete Section 7 and insert. This is the A7 amendment.
There being 17 ayes and 48 nays, the motion does not prevail. Is there any further discussion on House File 1?
Madam President.
Senator Latz.
In light of that decision by the body, I would like to offer the A56 amendment. Members, this amendment deals only...
Senator Latz, the Secretary will report the amendment.
Senator Latz moves to amend House File Number 1 as amended pursuant to Rule 45 adopted by the Senate February 17, 2011 as follows. Page 10, delete Section 7 and insert. This is the A56 amendment.
Senator Latz.
Madam President, members, this amendment addresses only the question of encouraging the Court of Appeals to go have their hearings in the local communities that are so interested in the results of the permitting process. It does not deal at all with the jurisdiction of District Court versus Court of Appeals. The language is crafted so as to not make any requirements upon the judicial branch, but rather to encourage them that the Court of Appeals shall, whenever possible, conduct its proceedings near where the project has been proposed. For all of you who represent parts of Minnesota that are further away from St. Paul than, say, Minneapolis, that you may wish to support this amendment to facilitate access to the judicial proceedings for your constituents. I encourage your support and I ask for a roll call.